Promote him. Promote him.
Yeah, I mean, you can promote Corey, that's fine. He may not want to be promoted. Hi, Carolyn.
Good morning. How are you?
Good. So I think we have a quorum. So you've got myself, Woody Chadek, who is our liaison and zoning bylaw working group from ZBA. Got Tom Callahan from the planning board. You've got Paul Caleri from the planning board. Peter Pescatori is our liaison from Open Space and Rec. Jack Creighton may be joining. He's our liaison from the select board. He had indicated he could join from 9:30 to 10:30. And then we have one member who can't make it. She's on vacation today, Cassie Malatesta, who is the other liaison for Master Plan Implementation Committee. So I know that a bunch of us I have a hard stop at 11:30. I know some others have some hard stops. And this group, we kind of previewed, and I previewed with you on Monday what we're looking to cover. There were really, two things. One, just an introduction of you to the broader zoning bylaw working group here today. And then a detailed discussion on building moratoriums, what it is, what you can and cannot do with temporary or interim zoning changes. And then secondly, a discussion relative to your experience with comprehensive zoning redrafts and reorganization and what can make for a successful one or a less than successful one. So 2 topics, moratoriums and that comprehensive zoning overhaul. At the end, there's some business that we as a working group have to talk about, but we wanted to obviously tee you up first and have that discussion. So with that, I will hand it over to you and let you jump in.
All right. Well, thank you very much. I think I have met nearly all of you, perhaps not Peter Pescatori yet, but I'm Carolyn Murray from KP Law. I'm very happy to be working with you folks as your recently appointed town council. I know that some of you I have met with, so you've heard a little bit about my background, but I guess maybe for Peter's sake, and Paul, I know you were, I don't know if you were at the beginning of the planning board meeting last week, so maybe you missed some of it. Just as background, I'm a shareholder, member of the management committee at KP Law. I've been involved with municipal law since 1994 in one form or another, including working for a municipality and being in-house counsel, and also just being out-house counsel, serving a number of communities in Massachusetts. My specialty really is at this point land use. We're all kind of broadly trained to be municipal lawyers, so we have to know the open meeting law, public records, and town meeting issues. But really, I get more into the weeds when it comes to land use issues, and work with a number of zoning boards and planning boards that I'm primarily responsible for. So Cohasset has been added to my list of communities that I'm happy to be the primary contact for, and as well as your land use contact. So I know I was asked to be here today to talk about a couple of topics, but I didn't know if, Katie, if you'd like me to pause there in case anyone has anything they want to ask me about, my prior experience with working on zoning redrafts, or whether you'd like me to just sort of get right into that.
I think since you've had a chance to catch up with most of us separately, I would say just jump right into the first of the 2 topics.
Okay. Well, it's on the agenda as building moratorium first, but if no one objects, I was thinking that the comprehensive zoning redraft is sort of a more broad topic, and I think everything kind of flows from that. And I know that I'm kind of a latecomer to this process that you folks have been between the Master Plan Implementation Committee and through your zoning bylaw working group. I'm the latecomer to this, so there's probably some ground that you've already covered. But one of the things that I was asked to talk about was my experience working with some other communities that have done these complete zoning overhauls, and some of the things that worked well, some of the things that maybe didn't work well, food for thought. If you've already made some decisions on these, I certainly respect that, and we just move on from there. But as I was thinking about, how you approach something like this, it can be really a daunting task. And one of the first questions that I've been asking, whether it has been Lauren or Katie, is what is our approach going to be? The approach could be one of many, but sometimes I have seen where a community might set up a committee such as this. They might decide, why don't we just do what I call the housekeeping things first? And that could be bringing all of your definitions into one consolidated definition section, tweaking your definitions so that your terms are consistent throughout, making sure that, I know some of you have expressed that, we haven't really touched the zoning bylaws comprehensively in some time, and we've just added these standalone articles to the end over the years. I kind of liken it to a patchwork quilt. It's like, oh, now we have to address solar. Now we have to address marijuana. Oh, we're going to create another overlay district. And we just keep adding a new chapter, as opposed to integrating some of those provisions from those separate standalone chapters into other parts of the zoning bylaw. So I call all of that sort of rearranging, reformatting, housekeeping. There's one approach where you could just do the cleanup work first, if you so chose. You could also decide, what, we're investing an awful lot of time in this, that while we're also clearly going to make some of those housekeeping changes, we want to address the substantive issues at the same time. And that, becomes the whole ball of wax all at once, is presented to town meeting. Then I've also seen some sort of like hybrid, where yes, it's housekeeping, but sometimes it's a little bit more of the pressing substantive matters, or maybe just addressing like the table of uses and the table of dimensional regulations first, and we work on some other chapters of zoning later. There's no right or wrong way to do it. It really is what you all feel you're up for. In some ways, I think it takes, I defer to you in that what your town meeting is like and how your town meeting may react to either approach. I was saying to Katie, I have seen some communities rewrite the entire zoning bylaw, and something that's akin to a small, if they even publish these telephone books anymore, that would be distributed at town meeting, and someone would get up to the podium at town meeting and slam down this document and say, do you have any idea what's in here? Do you have any idea how this affects your property rights or what you can and cannot do? Me either. Vote it down. And then you see, 18 months worth of work and a lot of money and sweat just go down the drain like that. I've also seen other communities, and this was just Eastham last year during the pandemic. They redid their zoning bylaws, and it got approved as part of a consent calendar lumped in with other articles. No discussion, no question whatsoever. So it really varies very much based on you knowing your community best and knowing how to read it, and deciding what approach works best for you folks. The other thing that I think comes into play is once you start to want to put pen to paper, the question really becomes, do we hire a consultant who helps us with all of this? Because you're all, you're all very busy people in your own rights, whether it is dealing with other jobs, other volunteer work, family, whatever it is. Yes, we're all busy. We've all got other things on our plates. Sometimes it's easier to hire a consultant whose job it is to make sure that the product gets delivered and drafted. But that said, you could do it in-house if you, if you felt that there is someone or some people who have the expertise to do this in-house. And yes, it's probably the ability to save a little money doing it that way. I'm not saying one is right or one is wrong. Like I said, I have worked with towns that do it either way. It really is a matter of what you think works best for you. The only thing I will say, regardless of the approach that you take, I do think one thing to be aware of is I think it is important to have one person really be the master keeper of the documents. If just for the sake of argument, I see, 8 different faces on the screen. If all 8 of you broke this down somehow and decided you're going to do the definitions, you're going to rewrite the harbor bylaw, you're going to do accessory dwelling units, et cetera, and hand it out like that, you're all going to write in different fonts. You're going to format this in different styles. You're going to use different terms. And it's going to take you're going to wind up with a product that doesn't look that much different from what your bylaw has evolved into, because that's been the approach over the years. So I do recommend that whoever this lucky person is, that there be one person who controls the document. We always know that this is the most recent updated version that incorporates comments from others. And if we're going to call something a house or a dwelling or a residence, whatever the term is, it's going to be consistently used throughout the document. And odds are that's going to be more likely to happen if you have a single person who is in charge of drafting as well. One of the other things I can't stress enough is there really has to be a commitment to read the documents as they come back. And I don't mean this in a disparaging way at all. From meeting and talking with most of you, I know you are very earnest, sincere volunteers who want to do the best for the town. But I also understand that if someone delivered a 250-page document on a Friday afternoon and said, this is for Tuesday night's meeting for discussion purposes, there's odds are there may be some folks who just don't have that time to read it as closely as you would like to. And I have seen that backfire. I will tell you right now, I have a piece of ongoing litigation pending in Superior Court because there was a provision that was, in the words of the town planner and the words of the planning board chair, this language just appeared in their zoning bylaw when they rewrote the bylaw, like gremlins just descended upon and put this language into the bylaw. And it was in there for 7 years before a developer came along and saw a way, I can take what would ordinarily be a parcel of land that could only be used for 2 single-family houses, and I can get 15 house lots out of this by invoking this provision. And as soon as this developer came in and filed this application, the folks in town were absolutely stunned and immediately took measures to repeal that provision, which is all well and good. It's never going to repeat itself. But my point is, it was in there for 7 years. No one read it in those 7 years. Nobody noticed it and said, what does this mean? Why is this here? And unfortunately, we've, like I said, we've been in litigation, I think now for about 3 years over this provision and this particular subdivision and the unintended consequence of it. Another thing that I would recommend, and I asked Katie the other day when we were talking, I said, who ultimately gets to make a decision here as to what goes forward to town meeting? Because I know we've certainly got members of the planning board, zoning board, the select board, and then your groups. You're not always going to agree on what is the best provision. But at some point, we've got to agree to disagree and we've got to move on. Because if you get stuck, then again, all of your work could just be for naught and the whole thing breaks down. So at some point, we've got to be willing to either compromise, or we've got to be willing to say, well, I didn't quite get, maybe it's the change on lot coverage, but I have to cede to the majority of the group. You've in addition to your working group, you then go back to your respective boards, got to do some marketing of this project to get it to town meeting. So I think at some point, the responsible party, whether that is this working group, whether this ultimately it becomes a product that the planning board is going to sponsor, or whether it's the select board, or maybe you do it all jointly, which would be astounding to me if you all did, but that'd be great. Move it forward. Sometimes, what is the expression that, perfection is the enemy of good? I know we might all have our own individual ideas of what changes need to be addressed, or what is a priority, or your better way of doing something. We don't want all of that to just be sacrificed just because we can't quite get past our own feelings on what, or our own opinions as to what the bylaw should or should not say going forward. It may not be, it's not a perfect product now. It's not going to be a perfect product when you're done with it. You could go to town meeting, as you all know. Town meeting could offer amendments from the floor, and sometimes those floor amendments can completely upset the apple cart. Sometimes they make sense. It's not going to be a perfect document when you're finished either, but if it's better than it is now, then you've at least made progress. And maybe there's another zoning bylaw working group that picks up where you leave off at some point, say 2, 3, 5 years from now, and maybe they finally get to pass some of the changes that you all debated but couldn't quite get consensus on. That's okay. I hate to see folks spend 18 months, 2 years, spend money on consultants, have a pretty good document, but not a great document, but a good one, that just winds up collecting dust on bookshelf in Lauren Lynn's office, because it never gets implemented, or we couldn't agree, so we couldn't bring it to town meeting. The other thing is when you're finally starting to gear up for town meeting, when you finally feel like you've now got a working product, in my opinion, you cannot do enough public outreach and public education to get folks on board. Because like I said, I've always got that town meeting member in the crowd who slaps down the zoning equivalent of the phone book on the podium and tells everybody to vote it down because it's just too complicated to follow. You want to do as much as you possibly can prior to town meeting to get the word out. And I've looked at the PowerPoint presentation that was submitted to the planning board. So I certainly see you've been collecting data. Looks like you've also been doing some surveys. All of that is great. But at some point, you're also going to need public buy-in and buy-in from some of your stakeholders. And I think you've got some stakeholders just by the composition of this group, but there's going to be a wider group out there as well. And they may only be interested in their piece of the zoning bylaw changes and how that affects them. But I think the more that you can do some public outreach, whether it is having some community meetings, obviously the planning board is going to have their public hearing on this. But to me, the planning board, by the time you get to the planning board public hearing, everybody should be, or everyone who wants to be, I should say, should be conversant in what is actually contained in this document, or at least conversant as far as what concerns them. There are going to be a whole bunch of other people out there that their eyes glazed over at the whole talk of zoning bylaw amendments, and they could care less, and that's fine. What you're really looking at is trying to identify your opposition, or trying to identify the folks who are going to be very involved in asking questions. And the sooner you can sort of identify them, hear what some of their concerns are, or maybe even address it, you might find that by the time you get to town meeting, you've really developed quite a following and gotten a lot of support for what you're looking to do. And when you have some of these public outreach meetings, my suggestion would be not to have a meeting where we discuss any and all zoning amendments at once. I would suggest breaking it down like by topics, so that if we're going to discuss changes to the harbor overlay district, or if we're going to discuss changes that affect, single family homes, or, what other aspects, people can look at your agenda, see what you're going to discuss, and decide whether or not, is this the meeting I want to go to? Or do I want to wait until next week's meeting because that's really the topic that's near and dear to my heart. It also helps keep the whole conversation focused, because if you put a draft of the zoning amendment out there on the website and invite public comment to a meeting on Tuesday night, you're going to be jumping around all over the place from topic to topic, and maybe it doesn't make a whole lot of sense to anyone, or feel like it's been a very productive meeting because it's scattered as opposed to being focused. The other thing that I would suggest is, as we start to get closer to this point of public meetings, we should always keep a master red line version of our zoning bylaw. And it's going to look like something absolutely crazy by the time we get to, I think of, the recent, the spaghetti strings that our meteorologists like to show on the weather forecast of all the different models of where the hurricane could hit. That's probably something that, your zoning bylaw is going to look like that, with a lot of different colors from track changes and comments in the margins and all of that. But ultimately, what we're going to need to answer is, what are the changes? And it does help if there is a red line version of, so here's what here's the underlying text as it exists now. And here is how it is proposed to be changed, so you can visually see it. And if you get to Article 12 and you see that absolutely nothing is redlined, good. You can reasonably anticipate there are no changes to Article 12 and move on. Then, of course, you want the clean copy, because people are going to want to actually see what that finished product looks like too. The other thing I suggest is an executive summary. Whether it's a 2-page narrative, or maybe it has to be a little bit longer, that just kind of hits topically. Yes, we know that we're consolidating all definitions into one section. Yes, there might be some changes to the dimensional regulations or the table of uses. We don't have to go into a whole lot of detail, but at least it's enough to alert someone that if this is a provision of the bylaw that concerns them, go and look at it, because yes, you want to see what those changes are. I also, sometimes I've seen this done as almost like in chart form, like a flow chart form, or that if we're also rearranging things in the bylaw, sometimes definitions are at the beginning, and some towns like to put definitions at the very end. If you're just, doing some moving like that, sometimes having a flow chart that says, Article 1 definitions can now be found at the end of the document. Something, some things like that really are useful tools for people who are trying to, haven't been zooming in publicly to your meetings over 18 months, but that are actually able to pick up the document and see what changes are proposed. But this also comes in handy at the time when this finally has to get submitted, either for the warrant for the town meeting or to the Attorney General's office. The Attorney General's office would prefer that we publish the entire text of the zoning bylaw in the warrant. That would be their best practice, to just put the whole thing out there. That's not always desirable. That significantly increases the size of the warrant and mailing costs and all of that. The Attorney General's office will accept a reasonable summary in the warrant, so in lieu of publishing the entire text. So preparing that executive summary might be helpful for public outreach, but it's also going to be helpful for purposes of the Attorney General satisfying the warrant notice requirements. And then, of course, we can still refer people to a website or to the town clerk's office, or where at town hall they can go to get a hard copy of these. But in recent years, when the Attorney General's office is reviewing major rewrites of zoning bylaws, they often reach out to us as town council and say, do you have a red line version of this? Because they also want to focus their review to where are the changes. They don't necessarily want to waste a lot of time looking at text that hasn't changed. So if we're ramping up and preparing those documents to begin with, we're just at one step ahead of things when it comes to final review process by the Attorney General. those are really like the main, takeaways from what I have seen done well and not done well in some past experiences. And I'm happy to answer any questions, or if you had any different ideas, happy to offer some thoughts.
So Carolyn, there was one other topic that we had just kind of previewed on Monday, and you kind of covered it in pieces, but I just wanted to be clear in terms of, you outlined a little bit the consultant versus in-house strategy, but there's also your involvement as town council slash land council. So I actually wanted you to speak a little bit about how it's best for you in terms or to work with you in terms of you could do just the final review, or we could use you in a hybrid situation between that consultant and in-house. So if you can comment on your role as town council slash land council and how it's best to interact with you as we proceed down to these final products of master red line, clean copy, and executive summary of the work, that'd be helpful.
Sure. And I won't say this just for the benefit of members of the select board who are joining us, who obviously want to always keep your eye on the legal budget. But I will work with you with whatever way you think works best for the town as a whole. So I have served as the consultant, if you will, to zoning bylaw groups such as your own, where I've attended every meeting and I've listened, and then I've been the scrivener, the person who's charged with, okay, by our next meeting, we want you to prepare a draft of the bylaw that we've just, kind of outlined for you. I've done that, and I've also been in the position of a bylaw working group has met for several months all on its own. And I suddenly get the 300-page marked up document that gets emailed to me saying, please review and comment. Sometimes I find it hard to get that 300-page document and start reviewing it, because not having necessarily been part of the board's discussions, I don't even know what's in it, or what to expect. And if I start to notice things like, oh, well, you've deleted this entire section on, a lid provision, let's say low impact development provision that has been completely removed from this section. Was that intentional? Or was it something that in the drafting was an oversight and we really did mean to put that back into the document? Not being part of the conversation, I don't know. So you wind up getting an awful lot of comments like that might be frustrating to you, because you think, oh God, we discussed that. We know that was an intentional change. Let's just get to the things that are really pressing for us. So coming in at the last minute will be a little bit more difficult. That said, I don't need to be at every meeting. A lot of what you need to discuss as a board, they're policy decisions. It's not up for me to decide what should your frontage requirement be. Should you increase it? Should you leave it alone? Should you do this? Should you do that? That is not my call. That is up to you folks to decide. My job is to make sure that if you decide frontage should be 150 feet, that's the right number that's put into the final draft zoning amendment. One sort of a hybrid approach that might work well is bring me in periodically as you start to feel you are discussing substantive changes, or maybe even reviewing some draft language. Bring me in at that point so that we can touch base from time to time, so I can get a sense of what are some of the decisions the board has been making. And maybe there's also something I want to ask, did you even consider this? Or did you even have a conversation about this? Or there might be something that you're thinking of doing that I know can't be done. And maybe I could offer some input and save you some time discussing some of that. So maybe at certain points, whether it's quarterly or as you start to really get into reviewing draft language, maybe that's when you start to bring me into some meetings. At the same time, you could also just, as draft sections of the bylaw are being prepared, you could always email proposed language to me to review, and I can be commenting as we go along, for example, I think I got an email this morning about, we're looking at some lead protection language, and we want to be ready to talk about that with the planning board on the 22nd. Okay, that's fine. We can do it in sort of piecemeal fashion like that too. I'm not looking, if you decide that what's best is to hire an outside consultant, and I've worked with Judy Barrett, I've worked with Bob Mitchell, I've worked with Lisa Mead, I've worked with probably most of the people who would wind up responding to an RFP like this. I don't need to duplicate efforts. I don't need to feel, to put my fingerprints on something that they have already done. But I do, at the end of the day, I will be the person at town meeting when the question comes up, or maybe even at the planning board hearing, when a question comes up, heads are going to turn towards me and say, well, town council, what is the answer to that? So I do have to be in the loop to some extent, but I don't have to be at every single one of your meetings along the way.
Yeah, I'd like to, you mentioned the select board. By the way, Caroline, you've been very good. Thank you so much for spending time with us.
Thank you.
It sometimes can be a little bit tedious to listen to us, but anyway. Listen, your point about procedure is very, very well taken. There's nothing more important than the town, and not just this board, but the other towns and commissions and the population, the citizens know what the procedure is. And there's a lot of misinformation or incomplete understanding. So that would be very helpful for us to know. The other thing, I think I cannot speak for the entire select board, but I can assure you across town, one of the real things that we do need is, legal guidance as to what we can and cannot do, and to make sure that we do it properly. And of all the things that this town can spend its taxpayers' money on, spending it on that is money very, very, well spent. And a further point, your comment about finding out what the impact is earlier rather than later. I served on 2 zoning commissions in Boston. We rezoned this Fenway and rezoned Audubon Circle. Don't ask me how a guy from Cohasset ended up doing that, but I did. A miracle, I guess. I was president of a neighborhood association for close to 15 years. If you find out stuff early, you can deal with it. It's the later stuff that becomes controversial, or because it's not understood. So that was an excellent point. We can deal with it early, and a procedure that allows us to do that's very helpful. Anyway, Caroline, thank you very much. You've been very, very, very helpful.
Thank you. And if I could add just one thought to that, we sometimes forget, because we are so involved with town government, we know that we are a committee, and we know that this finished product has to go to the planning board for a public hearing. We know that the select board controls the warrant, and then off we go to town meeting. There are folks who, if you have, some of these public outreach meetings that I've suggested, there are some folks who are not going to know the distinction between that meeting and a planning board hearing. And they may show up at a meeting. Let's say you have a meeting in February,
Yes.
where you're starting to talk about a version of the bylaw. Well, by the time we get to a planning board hearing, or even a town meeting in May, that language could have changed significantly. We could have gone in a completely different direction. So, in addition to, the documents, the information being out there, and I can help prepare this, but mapping out for folks, everyone always wants to know, what are the next steps? Because they want to know how many opportunities they might have to weigh in. But I think it also helps them to understand that just because you showed up at one meeting in February doesn't mean that this is going to be the final document that you're voting on in May.
I think that
Yes.
that process comment that you made, Jack, was a really good one. And I think we're at that moment where laying out the process and frankly, the process for resolution of differences as we proceed through this is going to be important. I emphasize to Carolyn that the zoning bylaw working group has no promulgatory power. Our job is to make recommendations to the planning board and to the select board. And so ultimately it is those two votes that carry this forward. However, I do think that outlining process and procedure upfront so that it's very clear to the select board and very clear to the planning board and everybody's in agreement is a critical step that we should take in the next couple weeks so that we kind of upfront. And then to Carolyn's point, that's a piece of the education process of the community as to how this bill becomes a law. I have that sort of PBS.
Yes, Saturday morning.
Exactly. We sort of have to have the similar equivalent for zoning bylaw. We have to have that jingle that everybody knows of like, here's how the zoning redraft was done. So I'm going to open it up to other members of the group. I think today was really to educate us. We need to take this and kind of process it and come up with final thoughts. You've raised a lot of great points, but I do want to open it up. Tom, I think you have something that you wanted to ask or say.
You think?
Yeah.
I'm free to 4 o'clock.
I gotta be in court soon. That's why I'm all dressed up, so I can't be here all day. I think my positions are very well known. I have done a redraft of the entire bylaw. A lot of it is substance. 2/3 of it is housekeeping, including moving a lot of administrative crap out of it and putting them into a set of regulations. I have an outline for it that says what's changed, what hasn't. It is mostly redlined. It can easily be fully redlined where the changes are. Could it be separated from the housekeeping going forward without the substance? It's hard because it's all been moved around and renumbered, but yes, you probably could do the housekeeping superimposed over the current organization of the bylaw if you had to, but I would think not, just because there's terminology changes again for the consistency's sake, even in the housekeeping stuff. So I don't think our town meeting is that stupid. I think they can handle the whole thing in the way we present it to them. My recommendation on that is that when we get to actual town meeting, that the redo of the bylaw be a separate night from the rest of the warrant, because I just think it will need that focus. And, the public forums, I thought this in my head too. I think that should be done in a series of them. I would suggest Saturdays in the gym at the high school so we can, the auditorium, so that if we do get a crowd, we can handle it. Do it in pieces, that's fine, but we should start that probably in January. My issue at the moment is getting this group to focus on the rewrite. I distributed an outline to Katie and Woody last week, for example, to just show what isn't changed. Like I have not written any changes into our parking regulations, our sign regulations, our watershed protection and floodplain regulations, and if there's things that are not proposed for change that people think we need change, best to get that out early, because where there is the substantive change in the definitions, table of use regulations and the table of dimensional regulations, that's going to take more of our time to review. I've updated it as of last month. And the updates were to account for the articles we passed in the spring and the articles we are proposing for the fall. I'd like to just start breaking that down amongst our group first, and then in public forums. And start with the easy stuff, the stuff that isn't changing, and the housekeeping stuff. If people think our parking regs need to be changed, let everybody know that. If the sign regs need to be changed, let it know that. But, we don't need, between the people we have here, including Carolyn, we don't need somebody else from the outside who doesn't know the town to write the bylaw. Selling it, that's fine. I don't care, but we're all smart people and know we need to do public forums before this. It's just a question of when and in what manner and how we're going to break it down. But that's all I have to say. So, I mean, it's ready for people to read and, comment, however you want to break it down. The outline of the proposed chapters is done. I could share that with everybody and people. I'm just at this point looking for feedback and actually focusing on what is written. And I'm not saying what I wrote is the most beautiful thing ever written, but it's a starting point. We, just like when we're doing individual bylaws, we have to start with the text of something as the beginning of a discussion point. And right now we've been doing a lot of theory, for example, about the size of houses, but let's get to the substance of it. So however you want to do that, but it's all ready to be looked at.
Well, I think I'd like to, separate from this meeting, and again, I'm cognizant that I want to get to building moratoriums, but I'd like to pull the zoning bylaw working group around in a separate meeting about housekeeping versus the substantive plus housekeeping strategy. I think I know where we're at, but I think we should make a formal vote or recommendation relative to that. I think we need to finalize exactly the role of the consultant. Tom, I think I've heard and others have heard that you don't feel like we need a consultant to write, but I absolutely feel we need a consultant to help us with the public forums. That is a huge lift. I personally don't have the bandwidth to be diligent about reading the whole documents, as Carolyn suggested is a must, and write PowerPoint presentations to educate the community. I literally don't have enough hours in the day and be able to do that. So I feel really strongly, and we've got a grant in process and we've got a request in a special town meeting to have funding to help us with that. But we can't lose focus on the fact that if we agree on that point, we need to get a consultant hired ASAP and get them on board to help us begin to do the public forum piece of the work. And then I'd like to address formally, Jack, your recommendation that we outline and agree on the process and procedure upfront with all three boards. And I think if we have the process and procedure and whole versus housekeeping and consultant versus in-house, those three questions answered, we will be well on our way to jumping into what Tom wants to do, which is get at the meat of writing the document. So that's kind of where I'm at. Are there any other comments, Woody, Peter, or otherwise, in terms of people want to add in? Woody?
Yeah, no, I agree with you. I think it's premature to jump into reorganizing per se. I think we've got to take a look at what sections and maybe subsections need change because they're problematic, that we have a real problem in front of us and want to solve it. And I'd rather see a consultant coming aboard rather than try to do it all ourselves. I think both from the standpoint of clarity of language as well as the legality of what we propose. Anytime we change more than 2 or 3 words, we have to really think about impact and is it allowed under general laws or case law. So I'd rather do it step by step as Katie's proposing.
Okay. So I think, again, I'd like to kind of close out the conversation and have Carolyn move on to the second topic, which is building moratoriums. We also have work as a committee. I'm sorry, Paul, you have your hand raised. Paul Cleary.
Thank you. Yep.
Yep.
Can you hear me now?
Yep.
Morning, everybody.
Morning.
Lovely day here in New York. Let's see. So happy I could join you guys this morning. Tom, I'm just curious, that document that you have been working on for a while, and shared with Katie and Woody. Is that red line was suggested, or is that creation from, you know, all the work that you've put in?
Well,
Paul, you-
everybody saw the first version of it in the spring.
Yep.
I just updated it through the changes that we've made at last town meeting and proposing for the upcoming. And I also want to say, by the way, that nothing I have written is, you know, my own radical idea. It's stuff that I've heard from, you know, being involved in this town for 30 years and from working on this committee for the last year and a half. You know, I don't want somebody to get the impression that there's radically new stuff. Yeah, it's some of my spin. I'm sure there is some of my spin, but it's all things we've been talking about, just put on paper.
Yeah.
Uh,
And Paul, you may have not, I can't remember who was at that meeting, but we went through the revised table of contents as Tom had proposed, along with the actual text of the draft was circulated. And again, there's a lot of great reorganization and housekeeping that Tom has thought through on our behalf. The substantive piece is where I think we have not spent any time, to Tom's point, jumping into the substance. That the reorganization and the table of contents in terms of how we might improve what we have today, instead of it, as Carolyn said, you know, one chapter being added on the end, instead of integrating it into a holistic document that is internally consistent, I think is really what one of the really value adds of what he had drafted. So, you know, that draft has been circulated in the spring. I'm happy to recirculate what Tom just sent to Woody and I, but I was also cognizant of not hammering people with too much as we're kind of gearing up for some special town meeting. But I will send that out today so that everybody has it, in all fairness.
So just so you know, I was just asking just for a point of clarification, and I apologize that the space that I'm in is loud. I'm at a Pandora, where am I? Panera Bread in New York working. So I'm just trying to, you know, be on the meeting if they're cranking the music here. So I apologize for that in the background, but I'm doing the best I can here, as we all are, in this current environment. But no, my point was just literally for clarification. I didn't know if it was a red line version, like council had asked, that we should try to, you know, continue to move forward with in that fashion. That was really all my question. And
Yes.
I think I saw the original version. I just don't remember it. It's not here in front
Katie,
of
why
me.
don't you recirculate it?
Yeah, I will.
So that we were not dealing with
The
two of us know and three don't.
Correct.
the outline, the outline is one thing. The whole bylaw, yes, it's redlined.
Perfect.
It's redlined where it needs to be redlined. I mean, the thing like the table of uses and the table of dimensional regulations is completely new so it's not in red ink, it's in black ink, but we all understand it's new, but yeah, everything else is redlined.
Okay. Well, I will recirculate that. And again, I'd like to
recirculate the outline, but if people want the whole damn thing, it's, you know, 50,
Well, if you're going to refer to the whole thing, I think we have to see the whole thing.
all right, fine, it's 55, 60 pages at most.
Well, then don't circulate it and we won't deal with it.
Yeah, no,
And that's easy too.
Okay.
All right. I will recirculate the table of contents because I think that's going to be helpful for people to understand and envision what a reorganization might look like of our existing articles into a more cohesive format instead of this chapter by chapter. And then I will also circulate the red line of the total document. Tom also, as part of that document, pulled a lot of the rules and regulations and the application.
Yeah, all the application stuff is out, and again, in the version, it may not say it where it was pulled out, but you'll just notice it's gone. But So, that's not redlined in that sense, but it's just not there anymore. But the substantive changes are all redlined.
So there's 3 documents that are coming away: a table of contents, a red line version of the substantive zoning bylaws, and then the third is the rules and regulations and application procedures, because as we all know, our application procedures are repeated ad nauseum in basically all of the overlays plus.
I have a process question for Carolyn. Carolyn, do rules and procedures of various boards require either the approval of the select board or a town meeting vote, or are individual boards based on their required voting, let's say 4 out of 5 or whatever the supermajority is, can they adopt these rules and regulations on their own?
Usually the authority to adopt regulations comes from some sort of statutory or even a bylaw provision, but rules and regulations do not have to go to town meeting.
Okay,
And
well, that's a blessing.
they typically only require a majority vote unless a board has imposed some greater number on it.
Now, does the select board then have to stamp its approval?
No, they do not.
Okay, great.
But I guess as we're technically talking about it, not to get detailed, but since we're excising out of a bylaw, we need the annual town meeting to approve the excision of that language. And then we need a separate vote of the planning board to approve the new rules and regulations. So it's kind of a 2-step process where we can't have the planning board approve new rules and regulations without the annual town meeting vote up front to excise it.
I think
You don't need a separate vote to excise, because the new bylaw will just not have it in there.
Right.
And
It's changing the bylaw.
And in preparation of that, the planning board, it's a question of timing of when they implement what was in the bylaw as a regulation, maybe the day after town meeting.
Well, technically, Tom, I think we need town meeting approval to delete language from the bylaws. And that's what I'm suggesting. It's like, we will need approval for the deletion.
No, we'll need approval for the new text of the new bylaw that won't have the application stuff in it. It's not a 2-step process.
I think this is where we need Caroline to give us an outline of the rules and procedures. And I think one of the good things you've done, Tom, is to separate out where the various rules, restrictions, bylaws, where they properly live, because I think they're living all over the place. So consolidating that, and then having Caroline, sorry, Caroline.
It's okay.
But having her.
My whole life I've answered to both, so it's okay.
All right. Yeah, I answer to different things too, but this is a family hour here. But having an outline from town council on the procedures would be very, very helpful for all of us.
But I could just weigh in on, I think both Katie and Tom were sort of saying the same thing, but maybe saying it differently. That we don't need to have a separate town meeting vote to agree to remove rules and regulations from the zoning bylaw. When the entire amended text is presented, town meeting is going to be asked, voted up or down. And we assume now that the text they're going to be presented with will have removed all of that language from it.
Yes, I agree.
Okay. All right. Thank you for helping us on that one.
Katie,
right.
I'm gonna have to run at 10 minutes of.
Okay, well then
5 minutes off, just a heads up.
Well, then I'm going to have us hop to the building moratorium. And Carolyn, here, as I kind of outlined for you on Monday, the goal is really education. The concept of a building moratorium was kind of tossed into our thought process by the planning board at the August 11th meeting. And the context of this is that building moratoriums or temporary zoning is used as a tool by some communities when you're going through a comprehensive zoning bylaw reorganization to allow you to freeze certain uses or types of development in specific districts while you're working on the amendments that you intend to unveil in a broader comprehensive overhaul. So that's the context. But what we agreed at our September 2nd meeting is that we were kind of flat-footed in terms of literally understanding what a building moratorium is, how do you draft one that will get AG approval ultimately, and just kind of general thoughts as to how this could be effective and what are the watch outs in terms of unintended consequences, whether it's accelerating development or having people do an end run that you really can't block. So that was the goal, again, was education of the working group. And we can take this information in a separate meeting and really say, okay, what do we want to do or not do with that information? So I'm going to hand it back to you, Carolyn.
Okay, so Katie, you had also circulated to me, and I think that you probably had shared this with the rest of the working group, a 1986 memo from the Executive Office of Community Development. And obviously it's out of date, but at least the principles that are stated in that memo are still accurate today and still essentially what the Attorney General follows. So, you know, as a general premise, yes, you can enact a building moratorium. It can be focused on just a particular type of development. You know, it could be commercial development, or you may recall with more recently in the last few years when recreational marijuana was approved statewide, a lot of communities adopted moratoria because we've said we don't have zoning in place yet to deal with this sort of use. So it could be a moratorium that restricts a particular type of use. It could be a moratorium that just applies to a particular zoning district. But usually what the Attorney General looks for are two things. One is there has to be some sort of reasonable purpose that is stated. And you folks are all involved in a major comprehensive rezoning. And I think that right there, that's your purpose. You know, we might need to identify a little bit more when you decide what type of building moratorium you want to impose. We might need to add a little bit more in a purpose section as to, well, I understand you're engaging in a major rewrite of your zoning bylaws, but how does that interact with, and I don't know exactly what you're entertaining yet. I've heard something that might pertain to single family houses and something pertaining to the harbor, but I don't have any specifics. So for example, a moratorium as to single family homes, we might say, well, what is so problematic right now about single family home development in Cohasset that warrants having to really impose a moratorium? Like we've got to articulate we've got to identify, like what is a problem, and then what is it by virtue of us conducting this comprehensive zoning study or zoning rewrite that we intend to correct. So that's one part of it. The other part of it is duration of time. And at one point in time, the Attorney General was advising us that they wouldn't approve a moratorium that was anything greater than 2 years. But I will tell you that they have been approving moratoria as to artificial turf fields for as many as 3 years. So I would just say, when you decide how much time you feel is necessary, give yourself enough time to really complete this zoning process. Don't go for 1 year, because I don't think you're going to have a complete zoning rewrite ready in a year, or you're going to kind of force yourself artificially with a quick deadline. But you know, think about something that's more between 1 and 2 years. 3 years, if you're going to impose a limit on a single family home, you might face a lot of backlash at town meeting for something like that. But the short answer is identify the use, identify the district or districts to which it may pertain, and let's really identify what is the problem that we're looking to solve. Some of the backlash, even with entertaining any sort of zoning amendment, anytime a property owner starts to catch wind that we're entertaining a zoning amendment that may make something more restrictive or, might now render their property non-conforming and therefore might require zoning board approval or something like that. you do tend to spur some people to act more quickly than they would if there was no zoning change that was being entertained. So there might be somebody out there who's sitting on, say a project for the harbor that is nervous that this board is going to propose a zoning amendment that might prohibit a use that they're hoping to develop. So that might force this developer to apply sooner rather than later because they want to get their application in before the bylaw changes. Yeah. Yes, sir. Sorry. I see.
Carolyn,
Mr. Pescatori, sorry.
yeah, if we put a moratorium in place and a property owner on the harbor, say, will be affected in terms of restriction on what they intended to build. What are the guidelines for them to have some sort of grandfathering protection? Do they have to have filed a building permit to be afforded any protection, or how do we avoid a lawsuit on if we've created a bylaw that's going to prevent them from doing something that they wanted to do?
Okay, well, let's just start with a general premise that anytime we amend the zoning bylaw, it is highly likely that as a result of that zoning amendment, we render somebody's property
Sure,
or
yeah.
somebody's use
Yeah.
non-conforming,
Oh,
right?
yeah, absolutely.
Whether it's just changing the lot size, something as simple as that renders something pre-existing, now it becomes non-conforming.
Yeah. So
So
what are
that,
the protections?
Okay, so, but if a developer, property owner obtains a special permit or a building permit before the first day of the planning board's public hearing, the first notice of the planning board's public hearing being advertised in the paper, any special permit or building permit that is in hand prior to that date, they follow the bylaw as it exists. In other words, they're not,
it
before
doesn't
that
affect
magical date of the hearing up in the paper, they can go
So-
forward
So it
with a
doesn't
building
affect-
permit, or
doesn't affect
special
them at
permit,
all.
even if it's a special permit that it doesn't affect them, correct? But it is going to apply, if, now this is always the strange limbo time. Let's suppose that a developer has something in process, and I have seen this happen before, where someone has submitted an application, let's say for a special permit. Meanwhile, that it is not concluded, so the special permit has not been issued yet. And in the interim, the planning board's first notice of their legal ad for their public hearing appears in the paper. Now, have a developer who, in theory, may be subject to that zoning amendment that we don't even know if it's going to pass. So this is sort of this, like I said, this strange limbo period where I have said to developers, look, you can proceed with your application before the planning board or the zoning board, but you recognize that we now have to apply the conditions that are contained in this draft bylaw because we've got to assume it's going to pass. Or you can withdraw this application and you can wait until after town meeting and we all know what rules will be in effect, because we could go down this process of applying special permit criteria, heck, even issuing a decision, only to then have town meeting reject the zoning amendment.
Yeah.
That's just a lousy situation to be in, just from a business and time management perspective. But and most of the time a developer will pull out, will withdraw.
Yeah. So if
sorry.
if a bylaw change, and correct me if I misstate this, if we're going to change the dimension requirements of a district, of a zoning bylaw, anyone whose property is affected will be grandfathered. Is that correct? You can't, you know, if we shaped it up or down, and they no longer, you know, and it affects something they wanted to do, right?
Mhm.
Is that
Mhm.
actionable?
The-
They're not grandfathered,
Okay,
the way I hear her say.
okay. So
Well-
height,
let's go to, let's just go back to what, to the scenario that if we suddenly decide that, lot frontage should be increased to 75 feet,
sure,
and there are a number of house lots out there, that are only 50 feet.
Yeah.
Those single family houses all remain, those lots all still remain. The only thing is they've now been rendered non-conforming. So now if that owner of that lot and that single family house on that lot that is non-conforming wants to put an addition on, and depending upon whether that addition complies with zoning, they may now need to not only just get a building permit, but they may also now need to go to the zoning board of appeals for, you know, for permission to alter that pre-existing non-conforming structure and or lot. So there is grant, you know, they are protected, not that they're allowed to continue. Even more importantly, what usually happens, a zoning bylaw changes a use.
right.
And now a use is no longer allowed in a particular zoning district. That use is allowed to continue to exist
Well,
and even allowed to change.
yeah.
But now they're going to be subject to ZBA regulation.
One of the things we're dealing with is height in, around the
Mhm.
harbor. So if we change the height requirement, then they'll be non-conforming. They may be
Right.
non-conforming, they may not be, but if they wanted to do something that was going to be outside of the new height requirement, then I guess it's up to us whether we allow a special permit to exceed the height that we now say is the bylaw.
Well, something like that, you know, height with it being a dimensional requirement that
Right.
typically would require, you know, variance from the ZBA. And I guess the ZBA might be hard pressed to say, look, no, town meeting was very clear. We wanted to make sure that we had lower or structures in the harbor. You know, we're not going to allow you to put up a 50-foot tall
Right.
structure.
Okay. I got it.
But then there's one other, I'm sorry, I don't have Tom. I didn't know if Tom was
Well-
trying to say something or,
Well,
sorry.
my concern about the two remaining waterfront properties in the harbor, the commercial ones, are restricted in their uses right now by the current zoning, the waterfront business zoning. My concern is that they are going to want to expand the overlay, which allows for mixed use, to their properties. If
Sure.
we put this moratorium in place, are they also prevented from coming to town meeting on their own with their own petition to expand the overlay zoning? Because our concern as a group is, yes, we might, you know, we're going to review the uses in the waterfront business district, and we might allow mixed use, but we want that on our terms rather than their terms or the terms of the current overlay bylaw, which has its problems, height being one of them. So I just want to know, can they still petition to change the zoning while we have a moratorium in place? Because that's the real fear I have.
Well, as you know, if they get a sufficient number of signatures on a zoning amendment, the select board has absolutely no discretion other than to put that on the warrant. Whether or not town meeting then approves something like that remains to be seen. And I think it would be an uphill battle at town meeting, to be honest with you, where if a moratorium was imposed and then someone came back afterwards to say, well, we want you to lift the moratorium for our purposes.
Okay.
I also think that, you know, and depending upon how they actually craft it, I'm not saying it's impossible, but they'd have to draft it in a way that it becomes another zoning amendment that effectively repeals the building moratorium. And I think I think if town meeting has voted in favor of something 6 months later, I just don't see that they're going to vote to repeal it unless they really feel that there was, swelling of unintended consequences that they just didn't expect when they imposed the moratorium. The other thing that is a possibility, and this happens a lot, are, there's certain types of plans that can be filed to affect a zoning freeze. So developers will come out of the woodwork with a subdivision plan or even an A&R plan, an approval under the subdivision control law, not required plan. And depending upon the type of plan that somebody files, it could affect anywhere from a 3-year to an 8-year zoning freeze. So we could go through this effort to try to impose a building moratorium. And again, someone could then come in, the day of town meeting and could file a plan to say, well, you guys are going to go ahead and you're going to adopt the zoning bylaw, but I'm going to freeze zoning as it exists right now today before town meeting ever votes on this. So, sometimes it can spur development and sometimes it can spur other actions that we'd rather not see, but unfortunately the Zoning Act does allow for those measures.
This is a very good thing that I think we're looking for your guidance. Exactly what are these trip times? What times? When does it start? And when can they kind of circumvent what they see coming? And this is where your advice is invaluable because we really need to know those specifics.
Yeah. If I could summarize, just so I make sure I've got it clear, in terms of, I heard 3 different ways for a developer who's looking to move more quickly than the first date of the public hearing of the moratorium. One is to have a special permit or a building permit granted prior to that first date, and that's one end round. A second end round, and it sounds like the trigger date for it is the approval of the building moratorium at town meeting, is they could file a subdivision plan or an A&R. So if I understood you correctly, special permit and building permit are tied to the day one of the planning board
Yes.
public hearing.
Yes.
And subdivision plan and the A&R plan is tied to the annual town meeting approval of the moratorium. So if they were to get a subdivision plan or an A&R approved, they could have a 8-year zoning freeze in the case of a subdivision plan and a 3-year zoning freeze in the case of an A&R.
Correct.
Okay. Okay. All right. Well, that, again, these are all, I mean, as Jack said, these are the details that we need to understand. But I guess the reason that we started this conversation is that in terms of reasonable purpose, one of the crucial underpinnings, if you were to consider a building moratorium, is that you're involved in a comprehensive redraft, which we are.
Right.
Legitimately.
Or a study,
Yeah.
one or the other, but I consider a comprehensive redraft a form of a study because you are analyzing how things work and how they could be changed.
Yeah, we've been at it for 1.5 years, so.
Yeah.
Right. No one's going to say
Okay.
you're not putting the time in.
Don't say that, Peter. That's depressing.
Yeah, it's been 1 year. Come on, guys. We've only met.
Well,
for
but we've gotten three bylaw changes approved, and we've got another 3 coming up that we expect will be approved. So we're making progress.
Making progress. But there is this moment in time where we have an opportunity to consider building moratoriums where we couldn't at any other point. And so this has to be approved at town meeting. So we've got a chance, obviously, for December 13th. And then if we, for some reason, feel like whatever, we won't put in place, we could have another bite of the apple at annual town meeting in the spring. But there is this moment in time where us thinking about it. So again, the goal was education. So I want to make sure that everybody's questions have been answered. So Woody?
Well, I've got one other question. You started off, Carolyn, by saying that it might apply to a particular type of development or type of use or a zoning district. So let's say we wanted, and I'm just making this up, I mean, there's certainly no consensus. We wanted to put a moratorium on multifamily developments. or we wanted to put a moratorium on mixed-use developments throughout town, not in the harbor per se, but everywhere. We don't have that many. Is that also okay, or does it have to be tied to a particular district as well?
It doesn't have to be tied to a district, no. It does have to be tied to, again, let's make sure that we can articulate why we would identify or single out, mixed use, as opposed to, say, other types of uses. What's special about this that we feel we need to impose a moratorium? And then what is it that we hope to accomplish by studying it or changing the zoning?
So we need a modifier to our universal reason of we're doing a bylaw review. We need a specific modifier for a type of restriction.
Right, because if we just said broadly, we're in the process, that the bylaw, dates back to, or hasn't been, significantly revised in 35, 50 years, whatever it's been. And we're in the process of overhauling our zoning bylaws. Well, that would be an argument for imposing a moratorium on everything, right? That in theory, we could be changing all sorts of things. So why shouldn't we impose a moratorium across the board on everything? Versus when you then start to say, we want a moratorium on mixed use, we have to say more than the fact that we're just engaged in the zoning rewrite. We need to also identify, well, what is special about mixed use or problematic about how mixed use has been coming about?
So
and
we need to
how is
have a
it that
specific
we intend to
modifier.
address it?
Yeah, okay.
Okay,
Mhm.
that's helpful.
Okay.
Yeah, I'm not sure we'd want to stop mixed use in the village. We've got some good projects going in that the village needs.
Nobody's proposing mixed
I know,
use.
I know.
That's
I
just
thought
an
you were just,
example.
yes, I know. I assumed you were, but
And they have a special permit, so they're already protected, correct?
no, not if
Oh,
there was
yeah.
a
They
moratorium
got anybody with a permit before we do is protected.
That's
with
it.
a permit, but
Yeah, so the ones you'd be concerned about already have their special permits. One Pleasant Street.
yeah, no, I'm concerned about new proposals.
Oh, no,
I wouldn't want to necessarily stop new proposals in the village, but I realized what he was using it as an example. I get it.
Yeah. Okay. Any other questions from folks on building moratorium? I think this has been really helpful for me to clarify kind of,
Yeah, no, I think at least I've got a pretty good understanding.
okay.
Yeah,
So,
thank you. Thank you very much.
Yeah, this is great.
Good.
But can I just say, the bottom line is whether we do a moratorium or if we go forward with a bylaw change on the height in the harbor, sneaky developer, new owner of some of the properties could file a plan and freeze what we have today for 8 years, no matter which way we go.
They could.
Mhm.
yep.
And
Important to know
that's
that.
that's their end around your goal. Yes.
Yeah,
Sorry, I've got
the
one
town-
last question for Carolyn, and that has to do, sorry.
So there is a poison pill.
There always is.
Yes.
Oh, perhaps.
Ruby?
The other thing I'd just like to know, given that the document that Katie circulated that you waived is it's 45 years old. Have there been any significant changes via the case law avenue to the moratorium beyond what you've described, or is that you mentioned that the principles still seem sound today?
Yeah, the principles are still sound. There have been a few cases since then, but still, for the most part, the moratorium has been upheld. And then more recently than that, there are just Attorney General approvals of bylaws imposing a moratorium that then refer back to these cases. There's a Chilmark case, there's an Arlington case, there's I think a Bill Ricca W.R. Grace case, and a Zuckerman case. Those are like the 3 or 4 cases that all address different aspects of an attempted moratorium. And there hasn't been much more case law since those.
Okay.
Woody, do you want her to circulate the
If it might be germane and to our situation, I mean, I don't know what these deal with. They could be dealing with commercial structures or uses that really are not our focal point at this juncture.
Well,
Yeah, if you think
I
it
could
might be
certainly-
germane, I wouldn't mind reading them, but not if they're off topic for
Yeah.
us or off whatever.
again,
I
80
think the most important thing is that we know where the tripwires are. We know what we should not do.
Yeah.
And if we do go forward, we need to know the guidelines under which we may go forward.
Well, and I think I also am super clear that whether it's building moratorium or as Thomas suggested, an amendment at a future town meeting, the developer's ability to do an end run in terms of the timing of a special permit or a building permit or a subdivision plan or an A&R does interfere with our best intent. And we just have to be cognizant of that no matter what route we choose, end runs are possible. But again,
And this
nothing
becomes
perfect.
like one of those unintended consequences of the public outreach. Here I am advocating, look, get the word out there, educate your voters so that you spend less time at town meeting debating some of these points and you build consensus. But the moment you put that document out there, even in draft form, it also falls to developers and property owners who take a look and say, uh-oh, I've got to file a plan next week because I can't have them tying my land up like this.
Yeah. Okay.
And they will, but guess what? If they do, without thinking it through, then they're stuck with that. And they may rue that they jumped ahead of where they should be.
That's possible. You're right.
Okay. Well, thank you, Carolyn. I appreciate you joining.
Thank you very much.
Thank you very
You're
much.
welcome. Glad to
Thank
be
you.
with you folks.
All right.
Yeah.
Very
Thank
good.
you.
All right.
I'm going to let Carolyn
Have a
go.
good rest of the day.
All right.
I'm
It's gonna
bye-bye.
let me go too.
Yeah, I can let you go, Jack, or anybody else that needs to go. I really just wanted to cover two things, or
Okay.
really one thing.
Thank you, folks.
Bye,
Thank you.
Carolyn.
Bye-bye.
Thank you.
So I circulated this morning minutes for approval. So I would love to get a vote on approval of the minutes from September 2nd, 2021. So I make a motion.
Aye,
So moved.
aye, second, aye.
Aye, second. I, Katie Dugan.
Woody
Aye,
Chidick, aye.
Constitutori.
Hi, Tom Callahan.
Hi, Jen
Aye,
Orr.
Jack Creighton.
Okay, great. I'm glad Carolyn didn't witness that, but I think we got all the ayes in.
This is a little messy, but what the hell?
Exactly. The intent, the heartfelt intent was there. So the next thing was, we have this timeline relative to special town meeting. I do feel like we need one more run through of the exact language. Carolyn is actually reviewing the ledge protection one relative to the Mass General Law that Woody found. She'll have comments back to us hopefully by early next week. I think we need another run through on definitions based on some work that Woody did, which I circulated to everybody, which was 2 memos, one on single lot exemption, but the second one was a memo relative to, I think you titled it, Woody, sorry.
Residential lots.
Residential lots, there you go. So before we go before planning board, I'd like to have another crack at the language with the groups, which means another meeting. But I think it's a critical one before public hearings on October 10th.
I could circulate my tweaks by the weekend
Your tweaks to the language.
to our group,
Okay.
So
So I was
because
looking
we have a
at,
meeting next week as a
Tweaks.
bylaw working group.
that's what I'm trying to schedule. So I'm
Yeah.
looking at either Tuesday, the 21st from 12 to 3, Wednesday, the 22nd from 12 to 3, or Thursday, the 23rd from 2 to 5. If people can look at their calendars, Jen, I think if I
What-
posted today, we're good, right?
Yeah, I just, it doesn't matter, but I can't do Thursday. But I also wanted to just let you all know that I just got, and I circulated to you all that the AG approved all of the bylaw changes from annual town meeting. So, yeah.
Good.
Us, that's huge, okay.
Yeah. So
Go.
that's,
Let's
All
have a
right.
cheer. Here, here.
Katie,
Exactly.
I'm good on all 3 days of those hours.
Okay, Tom,
I'm good for Wednesday and Thursday. Tuesday.
Okay.
Yeah, Thursday would be preferable, but Wednesday.
let's,
Either day works for me, Katie.
okay. Jen, do you mind if
Can-
we do it on Thursday? Because I know these guys are, I know Tom and Paul are ready for a planning board meeting on Wednesday. So if we could do it on Thursday, I think it'd be better.
I could set it up
Thursday
for you.
so
I just,
far, yeah.
I'll be leaving early. I have to go to Boston, but I can set it up for you.
Okay, so can we do 2 o'clock on Thursday, the 23rd?
Yeah, I can do that.
All right. And again, the date we've got in mind is we have to be ready to present our case, but also the specific language by Wednesday, October 6th, which is the first public hearing with the planning. So
And can I just ask to clarify, are there tweaks to the text of the bylaws themselves
it's tweaks to the text of the bylaws.
Yeah.
as circulated 2 days ago?
Yes.
Okay.
As
And-
not circulated as of yet. I mean, Woody would like to.
Oh, I don't know who circuit, yeah.
No, that I circulated to you 2 days ago.
Yes, it is tweaks to zoning bylaw 2.
Okay. And Woody's 2 explanations for Articles 1 and 2, I think are great. They're just longer than normal that one finds in the warrant.
Oh, yeah, no, they were not
I-
intended to go
No,
in
I think
verbatim.
I think they're
They
far,
need to be edited down.
yeah, I
Yes.
think they're far superior, but I would leave it to you to try to edit them down.
Yeah, no, I mean, nothing would kill it faster than to have a page and a half of,
I think there's what we use for ourselves to get fully educated, which is what Woody has done. And then there's a redacted version, which
Yeah.
goes in the box.
Yeah.
But I think, again,
No, but I'll defer to Woody to do the redacted version first before I would take a crack at it, because he was the author of 2 very great explanations. So,
correct. So I'm going to post a meeting for Thursday, the 23rd at the 2nd. And what I will, when I post that and I will send out a packet with the latest article language, the notices of intent, which we have to submit on Friday, the 24th. And then I'll also recirculate Woody's memos. There's 2 of them on residential lot and single lot exemption.
I've
And-
got a suggestion, Katie.
Yeah,
Why don't, I mean, I haven't done the edits except
Yeah.
in my head.
yeah,
So why don't, when that document is ready, kind of attach that or have that be one of the 2 things you're circulating, the other being residential lots. I think they could be, the very compressed version
Okay.
could be read in light of what residential lots say,
okay, that's
rather than
fine.
have it just here, there, yesterday, today, tomorrow.
Mostly I wanted to get the date of the meeting agreed to so I can
Yeah.
post the agenda, and then my intent was to circulate the packet, giving you
Okay.
enough time to make the revisions.
Yeah.
But, so you're gonna see 2 things from me. One, Tom's work that we referred to during the comprehensive redraft, and then a packet for our meeting on the 23rd. So thank you, everyone, for your time today. I think this is a great conversation, and I think Carolyn at least really helped me. So hopefully it's helpful.
Boy, I like what she has to say. I must say, it's a breath of fresh air.
Yeah.
That's good to hear.
Nice to have a little confidence.
Yeah.
Yeah, exactly. And when I get comments back from her on the ledge protection bylaw, that will also be in the packet too. So
Okay, great.
hopefully we'll have a really.
Thank you. I'm going to have to run, as I said.
Okay.
Yeah, me too.
Thanks,
Thank you.
guys.
Thank you, everyone.
Thank you.
I'm gonna
I think this
adjourn
committee is
at-
doing an excellent, hardworking job.
Thanks, guys.